We are back. Sam Seder on the Majority Report. Ladies and gentlemen, it's always a pleasure to welcome back to this program the wonderful Ari Berman from the Nation magazine, among other things, also author of Herding Donkeys. And as you heard last week when we spoke to him at Netroots Nation, the author of a forthcoming book on the Voting Rights Act, which was dealt a serious blow by the Supreme Court yesterday. Ari, welcome to the program.
Thanks, Sam. And I guess, unfortunately, I just got a lot of new material for my upcoming book.
Indeed. These 2 days, in fact, have been extraordinary in terms of the consequence of the rulings that have been handed down by the Supreme Court, and frankly, the sort of shocking hypocrisy that has been paraded out by Ant and Scalia. But let's go back to the Voting Rights Act first. It was Section 4 that was struck down. Tell us what that ruling really meant.
Okay, well, the case concerns Section 5 of the Voting Rights Act, which is the provision of the Voting Rights Act, the most important provision, which says to states with the worst history of discrimination, primarily in the South, that they have to clear their voting changes with the federal government. So that's the most powerful tool in the federal government's arsenal to stop voting discrimination before it occurs. Now, the way that states are covered under Section 5 is under Section 4. Section 4 was originally written to encompass states where there was a discriminatory voting device on the books, like a literacy test or a poll tax, and there was less than 50% voter turnout in 1964. And that formula allowed them to get the Alabamas, Georgias, and Mississippis of the world who were doing the most discrimination.
And to be fair, the Queens, New York. I mean, there are
well,
other...
okay, it was later. It was also updated subsequently in 1975 to include places that discriminated against language minority groups that didn't pass out, for example, bilingual ballots. That encompassed Texas, Arizona, and parts of some other states, including parts of New York. So the formula originates in 64 and it goes up to the 70s. And what the Supreme Court said was that Section 5 in and of itself, the preclearance mechanism, is not unconstitutional, but that Section 4, the states that are covered under Section 5, is unconstitutional. So basically, Section 5 still exists, it just doesn't cover any states anymore, and thus is effectively dead.
All right. Now, there's a couple of questions I want to get to before we get back to this actual ruling. Under Section 5, for instance, let's just take Texas, because Texas was a prime example of this past year. And I know moments after the ruling, Texas basically said, we're back on in terms of our discriminatory voting rules. But in 2011, Texas passed, the Texas legislature passed an incredibly draconian voter ID law, which by their own reckoning would essentially disenfranchise 4 to 8% of their registered voters, somewhere between 600 and 900,000 people approximately, who were eligible to vote but didn't have the voter ID that they would need. It imposed a lot of difficulty on people because sometimes you would have to go 250 miles to get a non-driver's license ID, et cetera, et cetera. So walk me through that. The State Department, the Department of Justice says this does not pass muster.
Yeah, so Texas did two things. They passed this really harsh voter ID law and made absolutely no preparations whatsoever to ensure that people would actually be able to get that ID. And then they also passed these unbelievably racially gerrymandered redistricting maps that, despite the fact that 90% of Texas's redistricting growth came from minority groups, minorities actually had fewer seats in the new maps than they had before, which is just unbelievable. If you look at redistricting is supposed to account for population growth, and Texas basically did the opposite. They gained all these people and they gave them fewer seats. So the Justice Department blocked both of these laws, both the redistricting maps and the voter ID law. Then the state of Texas had two choices. They could either try to get clearance from the Justice Department, or they could go through the federal courts. They chose to go through the federal courts in D.C. The federal courts sided with the Justice Department in both of these cases. They found that the ID law would discriminate against minority voters, and they found that the redistricting maps were enacted with intentional discrimination, which is a very tough ruling to find. And so both of these were then blocked from implementation. Now, without Section 5, what would happen is that intentionally discriminatory redistricting map would be law immediately. The voter ID law would be law immediately. The only way to stop the voter ID law would be to hope for a preliminary injunction. The only way most likely to challenge the redistricting maps would be after years of lengthy litigation, after the maps are already in place, if there's already been elections in place. And so I think Texas is a perfect case study of why we need Section 5, and now we just have basically a third of the country where voting discrimination remains rampant that is now no longer under federal oversight. The federal troops have pulled out like they did after Reconstruction.
Okay, all right. So let me just walk through this now. Now when Texas then attempts to fight the Department of Justice ruling, and they go to court, is the burden of proof different than it would be if if Section 5 was not operational? In other words,
yes, well, absolutely, and that's a huge difference. Is the burden of proof is on Texas to prove that their voting changes are not discriminatory. That's another thing that Section 5 does that's so effective. Now, in court, groups, for example, like the Mexican American Legal Defense Fund, they're going to have to bring all the proof to show that Texas is discriminatory, which is a much higher bar to clear. So it's very, very, very difficult to win suits under, for example, other parts of the Voting Rights Act, like Section 2, or under state laws for this very reason. Section 5 is the only part of the Voting Rights Act and the only part of federal law that puts the burden of proof on the discriminators as opposed to those who are being discriminated against to have to justify their laws. And that's why it's such a devastating loss, and it's so difficult to find a replacement for it. And so really, I mean, I look at this as the most radical Supreme Court ruling on voting rights since they upheld poll taxes and literacy tests in 1903.
And in fact, that's what Eric Holder characterized the voter ID law in Texas as, basically a modern-day poll tax. All right, so now we should also say that not only is there a legal distinction in terms of the burden of proof, but there's also sort of, at that point, it also becomes a very practical distinction in the sense that you're talking about outside groups having to raise the resources to fight this, as opposed to the federal government doing, which obviously has a built-in apparatus, has expert civil rights lawyers, and has voting lawyers. So there's also some incredible practical implications that go along with both who the burden is on and the level, in terms of the burden of proof, both in terms of a legal sense, but also from a practical sense. So let me ask you this. The AG of Texas, moments after that, and I believe I think it was in Mississippi as well, I believe, also said that they were going to reinstitute their laws, which had been struck down through a similar process. The DOJ didn't pre-clear them. In Texas in particular, does that ruling, that voter ID law, still stand, or does it have to be relitigated now because the question is different?
So from Texas's perspective, it's like it never happened. So they are just going to enact their voter ID law, and groups are going to have to challenge it under other parts of the Voting Rights Act. There's also some question about what will happen with redistricting, because when the federal courts found that Texas had intentionally discriminated in drawing its redistricting maps, they kicked it down to a lower court in San Antonio that's currently holding hearings on that map right now. And so there's some question also of whether or not the maps that were drawn by the court are binding, or whether Texas can just enact the initial maps that it passed, which are incredibly racially discriminatory and which provide for no new seats for the large and growing minority population of the state. So there's a lot of questions here in terms of how this will move forward. But basically, right now, states are just proceeding as if Section 5 never existed.
And just basically waiting for people to come back at them with lawsuits, because the Department of Justice now has no longer any authority to stop them, because all of that is now moot. All right, let's move to the legal reasoning here, because it seems to me that from afar, you obviously dig into this stuff much more, but it seems to me that the court's reasoning was simply based upon a finding of fact as opposed to law. In other words, they didn't find anything necessarily wrong with the legal framework here. It is okay in principle for the Department of Justice to have a preclearance on some specific states. It's just that they don't like the formula that was developed to determine which states they are. I mean, this is stunning to me. I mean, because the court
it's almost like John Roberts just got rid of the law because he didn't like it. I mean, not because it violated any constitutional principle. There's a piece on Slate today by Richard Posner, a very esteemed conservative justice who teaches at the University of Chicago, who basically says that Roberts is relying on a principle that doesn't exist, which for a very high-profile conservative jurist to say that about the Chief Justice in such an important ruling is really, really, really shocking. And I think if you read Ruth Bader Ginsburg's dissent, which I encourage everyone to read in the VRA case, she makes it very clear that not only is Roberts totally ignorant of the law's history and its purpose, but that he's way overreaching in what the court should be doing. And we have Antonin Scalia saying today in the DOMA case, well, it's not the court's job to overturn democratically passed laws. Well, look at DOMA. DOMA is a law that even its co-sponsors have disavowed, whereas the VRA is something that's been passed overwhelmingly 5 times by the Congress, passed originally and then reauthorized 4 times by the Congress. If there's any law that the Supreme Court should have an incredible amount of deference to, it's the Voting Rights Act. It's one of the most successful and bipartisanly acclaimed laws in its history. So, I mean, I think this is going to be a very controversial decision, even in conservative legal circles for a long time.
Well, I mean, it should be, because this is from their perspective, and by their I mean these sort of strict constructionalists, those people who sort of have a problem with this sort of almost made-up concept of judicial activism. They always espouse the notion that in almost every circumstance you defer to the legislature, that courts should not be making laws in some respect. And this is a perfect example of their tremendous hypocrisy in this case. From the perspective of those of us who believe that the Constitution is more of a living document, that that legal principle that you necessarily defer to the legislature isn't always correct. It's less of a conflict. But for them who hold that principle in such high esteem, that's what makes this Section 4 striking down the Section 4 so stunning, because it seems to me, I don't even understand what the legal principle is that they're arguing. All they're talking about is they don't like the formula. They just think that the formula is outdated. They're sending this back to Congress, and Congress has the ability to make a formula, and we don't know. I mean, have they provided any sort of parameters?
Can I read Richard Posner writes in this Slate article? He says, Justice Roberts was relying on a, quote, fundamental principle of equal sovereignty, end quote, of the states. This is a principle of constitutional law of which I have never heard, for the excellent reason that there is no such principle. I mean, this is unbelievable that I can't emphasize enough. One of the most respected conservative legal scholars is basically telling John Roberts that there's no part of the Constitution that invalidates a law that he just struck down. I mean, this really is like bizarro world that the Chief Justice is relying on. I mean, he's had it out for the VRA for 40 years. I don't know why. I don't know if he got mugged by a black teenager or something when he was 12, and he's had it out for minorities ever since. I mean,
and now I should say,
crazy.
when you say this, he was drawing up legal memos during his time in the Reagan administration that were unsolicited in terms of how you attack this law. There's
a whole school of conservatives who came up during the Reagan administration. Clarence Thomas was another one of them, who made their mark by challenging laws that they thought benefited improperly minority groups, and that included unfair racial preferences. So Thomas was attacking affirmative action. Roberts was attacking the Voting Rights Act. And in 82, when Roberts was a young lawyer in the Reagan Justice Department working for the Attorney General, he was very strenuous in opposing another part of the Voting Rights Act, Section 2, which applies nationwide. And back then, what happened is the Supreme Court had ruled that you could only show Section 2, you could only prove Section 2 violations if you proved intentional discrimination. So not just evidence of discrimination, but intention of discrimination, which is very, very difficult to prove. It was proven, for example, in the Texas redistricting case, but it's very, very, very difficult to prove. Congress subsequently overrode the court and Roberts and said that, no, you don't have to prove intentional discrimination, just the impact of the discrimination. But if Roberts had won in 82, I mean, there would be many, many, many fewer minority lawmakers in Congress. That whole section of the Voting Rights Act would be weakened. And now, he's back, 20 or 30 years later in a position to just essentially invalidate a law because he doesn't like it, not because there's anything constitutionally wrong with it.
How much do you think, from a strategic standpoint, that John Roberts gave thought to the idea? I mean, because in terms of the story, okay, I think this, obviously, the day after the Voting Rights Act is gutted, we now get these rulings on DOMA, the Defense of Marriage Act, found unconstitutional. It's going to have, obviously, massive social implications across the country. We're going to talk about that in other parts of the program. The Proposition 8 thrown out for lack of standing, a ruling which I particularly don't. I like the result, but I don't like the ruling itself, frankly. But how much do you think John Roberts contemplates we want to put the Voting Rights Act out ruling the day before the DOMA ruling so that the Voting Rights Act, the utter shockingness of it, because it is, I genuinely think it's shocking, not just in terms of its implications, but this is made up from complete whole cloth. I mean, this is the functional equivalent. I mean, it is the Supreme Court making a determination on fact, which is just conceptually unheard of. The idea that they are making a determination as to whether or not not just that racism still exists, because if they found that there was no racism, there'd be no reason for Section 5, which they found no problem with, but that the way in which the fact finders are finding the presence of racism is somehow wrong. Do you think John Roberts made a strategic decision in terms of when these are released?
Yeah, I mean, I think that Roberts is very strategic about everything he does with the court. I mean, I think that's why he upheld Obamacare. It wasn't because he liked it. It was because he realized that he didn't want to make the court the central issue in the 2012 election and beyond, and he could extract enough concessions, for example, in allowing states to opt out of Medicaid expansion that would make it palatable to some conservatives.
That was also an incredibly bizarre ruling. I mean, the idea that the federal government could have shut down Medicaid for a day and then just relaunched the whole program, expanded, and that would have been okay. That was also a bizarre ruling, frankly.
Yeah, that's true. I don't know quite as much of the details of the healthcare ruling, but it did strike me as odd. And you looked at the affirmative action compromise. I mean, once I saw that there was this 7-1 compromise on affirmative action where they kicked it back to the lower courts and told them to apply a stricter standard for the University of Texas, I said, Voting Rights Act is in a huge amount of trouble. I mean, we already knew that to begin with, but it was clear that Roberts and Kennedy were saving their legal firepower for the VRA. And I want to say, not only Roberts, who I think has disgraced himself both with the VRA opinion and his dissent in DOMA, but I also think Kennedy shouldn't get off the hook there. Because Kennedy wrote the opinion in DOMA, a lot of people are going to praise him as this, moderate, far-thinking, progressive-minded judge. But he was the one who voted to get rid of Obamacare and who joined Justice Roberts' opinion in the Voting Rights Act case. So I really think that it's a sad day on the court where there really is no swing justice. There are no moderates on this court. There are some who may on one issue or another lean in a conservative direction. But clearly, this is the most radical Supreme Court that we've seen since the 1930s, and their decisions are having all sorts of impacts, mostly negative on society. We had one good day of decisions with the gay marriage decisions today, and then we've just had so many awful decisions, even beyond the Voting Rights Act, all the big business decisions, the fact that the Chamber of Commerce is 13-3 this term before the Roberts Court, that their cases are getting heard at an unprecedented rate. I think people need to be paying way more attention to the courts, not just the Supreme Court, but the lower courts than they currently are.
We totally agree on that. Now, I just want to get back to one more aspect of Section 4. Did the court, in basically throwing this back to Congress and saying, learn how to determine whether or not there's racism better, okay? Basically saying, we know better than you as elected representatives, and the literally hundreds of pages of documents and testimony that went into your decision to reauthorize the Voting Rights Act in 2006, was it, or 2007? What did they say? Okay, use these standards, decide within these parameters. In other words, did they give any instruction to Congress on how to measure racism better?
No, they really didn't. All they said was that that times have changed, but the Voting Rights Act has not, as if it needed to change. And people keep saying, well, now Congress needs to fix it, but I keep saying, well, you can't fix what's not broken. There was no reason to quote-unquote fix the VRA. We looked at this in 2006. The only fix that we would have needed was to go look at the 2012 election, see the outbreak of voter suppression nationwide, and say, okay, maybe we should be expanding the Voting Rights Act. Right. That was the only fix that needed to happen.
So, Ari, how does Congress deal with this? Even if there was,
I don't know. I honestly don't think that. I don't know if there is a way to deal with it. I don't think that they can rewrite the coverage formula based on some other definition and be able to cover the same states. I think the only way you could do it is to look at states. Maybe they had violations in the last 10 years, and say you're only going to cover states with violations under Section 5 or Section 2 that occurred in the last decade. Maybe that's a more narrow way of doing it that would be palatable to the Supreme Court.
But why 10 years?
I think it's very likely that they could rewrite the whole formula. It could go back in front of the Roberts Court, and then they could find Section 5 unconstitutional.
Why?
I don't know if they're going to stop
you're right
here, so I'm not really sure what Congress can do.
Why 10 years? If Roberts is saying 30 years or 40 years, that's too far to go back, well, then why is 10 years not too far to go back? Why shouldn't it be 15 minutes ago?
I think you
why
could make
shouldn't
a
it be
more
20?
convincing case that was more tailored, though.
I suppose, but what would also be more tailored would be 6 months ago. Right? That this shows the absolute fallacy of this ruling is that it is completely arbitrary and whimsical. If 40 years is not right, well, then you have an obligation to say what is the amount of time in which you can determine, is it one generation, is it 2 generations, is it 3 generations? This is the absurdity of this, and it also, I think at one point in his ruling, and I don't mean to get so excited about this, but I'm just shocked by this. At one point, he says that the Voting Rights Act should not be punishment for the past. It should be instruction for the future, or something to that effect. And this is what is sort of stunning about this, because this gets to the heart of the id of the conservative mind here. The idea that they perceive this as a punishment as opposed to a mechanism to ensure justice is, I think, a fundamental distinction. between which I think is the real tell here. They see this as some type of reparations, as opposed to making people and ensuring that people are whole going forward.
They view it as a debt that was already paid, as opposed to something that continues to show its value every single year. And I mean, that's what Ginsburg, in her dissent, had to remind the Chief Justice of. She had to remind him first of, Bloody Sunday in Alabama and what it took, people almost dying to pass the Voting Rights Act, and how long it took, 100 years after the passage of the 15th Amendment, which was supposed to guarantee the right to vote for minority groups. And then she had to remind the justice of the fact that the VRA was reauthorized in 2006, both because of the prevalence of second and third generation voter suppression tactics, but also because they made a finding that this stuff was going to continue to occur. And guess what happened? Not only did it continue to occur, but it got a whole lot worse.
Yeah, you made the point.
The voter suppression of 2012 was vastly worse than what we saw when Congress reauthorized it, which, if anything, should lead Congress to strengthen the law, not to get rid of it.
In your what I consider seminal piece on the Voting Rights Act that you within the Nation, I guess it was in February of this year, you made a note of Holder noting that there have been more lawsuits challenging the constitutionality of Section 5 over the past 2 years than during the previous 4 decades. The aggressiveness in which the attempts to basically unshackle these voting laws, which have been expressly intended in some instances and clearly after the fact shown to disenfranchise a specific group of voters, in other words, minority voters, is unparalleled. I mean, that's what is just so bald-faced about this ruling, I think, Ari. And it's, I mean, obviously, you know this, but it continues to just completely shock me.
Well, the trends kind of make sense, right? I mean, the explosion of voter suppression by Republicans has been accompanied by an effort to kill the Voting Rights Act. I mean, of course, if you're committing so many crimes, you're obviously going to want to try to kill all the cops that are preventing you from doing the crime. And so that's really what happened here. And so they go hand in hand. And I've said all along that I believe that the GOP's biggest voter suppression target was the Voting Rights Act, that all along during 2012 they had their eyes set on this. The court decided to take this case 3 days after Obama's election. And so, I mean, this is something where there's been 50 years of progress under the Act. Clearly the progress has been great but insufficient, and it's going to be very, very difficult to come up with any replacement. I don't think that's a reason for Congress not to try. I think it's very important for Congress to try, both to try to get a solution, but also to keep this issue in the public eye so people are motivated to try to address the problem, either federally or locally. I hate to suggest that Congress address some sort of grand bargain, because we all know how those turn out, but I do think there's just going to have to be some other steps of election reform to try to counteract this thing. Then there's going to have to be some way to get in front of, for example, voter ID laws, early voting, same-day registration. I mean, there's so many components now to election that, it might take some sort of compromise, a guarantee of early voting in exchange for mandating some sort of ID. I'm not saying I'd be happy with that, but I think we're headed to some sort of resolution. Otherwise, it's just going to be incredibly messy.
Ari Berman, Nation Magazine, thank you so much for joining us today and the reporting you've been doing on this. It really has been amazing. You've been telling us for literally for a couple of years now to watch out for this, and sadly, this day has come. Ari, thanks so much for your time.
Thanks, Sam.